I'm Daniel Benjamin, and I'm the president of the American Academy in Berlin. And I'm delighted to welcome you to this fall's Bertold Leibinger lecture, the 15th Amendment and the Constitutionalization of Democratic Self-Governance in the United States. This lecture will be delivered by Bertrall Ross, professor of law at the University of Virginia Law School, and this fall's Bertold Leibinger Fellow here at the Academy. I believe it's really important to remember those who have made what we do at the Academy possible. And so let me just say a few words about Bertold Leibinger, who those of you who are German will probably be familiar with. He was an engineer, a businessman, and a distinguished philanthropist. He turned Trumpf from a small family firm into a world leader in laser technology. He founded the Stiftung that is named for him, and during his lifetime he was renowned not only as a successful engineer and entrepreneur, but as someone deeply concerned with social values and cultural achievement. Bertold Leibinger also had strong ties to the United States. He and his wife moved to the U.S. in the late 1950s, and he worked in Cincinnati for several years. Thanks to the initiative of Bertold Leibinger's daughter, Regina Leibinger, who's a trustee of the Academy, the Leibinger Fellowship at the American Academy was founded in 2006, and it's supported annually by the Bertold Leibinger Stiftung. The fellowship aims at highlighting the bonds between the United States and Germany, and it also supports our work beyond Berlin, and particularly in Baden-Württemberg. Leibinger Fellows are drawn from disciplines in the liberal arts and the humanities, social sciences, and law. Past recipients of this fellowship have included sociologist Nancy Foner, historian Leora Auslander, literary critic James Wood, and many others. And I'm deeply grateful for the support of the Leibinger Stiftung and the Leibinger family. So let me now turn to our speaker. Bertrall Ross is the Justice Thurgood Marshall Distinguished Professor of Law at the University of Virginia Law School, a faculty that he has officially joined but not yet arrived at. I think it's worth saying that it's hard to imagine a position that really somehow puts all of the contradictions in American history into one short set of phrases more aptly than a position named for the victorious attorney in Brown versus Board of Ed and the first African-American justice of the Supreme Court at Mr. Jefferson's law school. So there's an awful lot of historical significance in that one title, and I know Bertrall is going to live up to all that. Bertrall Ross earned his undergraduate degree in international affairs and history from the University of Colorado at Boulder. He received his graduate degrees from the London School of Economics, where he was a Marshall Scholar. And let me just say, as someone purely objectively, Marshall Scholars are by far the best, much more impressive than Rhodes Scholars. And I say that completely objectively, no bias whatsoever. He also has a degree from Princeton School of Public and International Affairs and a law degree from Yale Law School, which means you just finished your studies, right? I mean, you've been at it for a while now. After law school, he clerked for Judge Dorothy Nelson of the U.S. Court of Appeals for the Ninth Circuit and Judge Myron Thompson of the U.S. District Court for the Middle District of Alabama. Bertrall Ross teaches and writes in the areas of constitutional law, constitutional theory, election law, administrative law, and statutory interpretation. His research is driven by concerns about democratic responsiveness and accountability, as well as inclusion of marginalized communities in administrative and political processes. Prior to joining the Virginia Law faculty, he taught for over 10 years at the University of California at Berkeley. He has, a drawer full of notable prizes, perhaps even of more recent vintage. He was appointed to the Administrative Conference of the United States, which recommends improvements of all kinds to how federal regulations are promulgated and programs are administered. And in April of this year, President Biden named him as one of the members of the Presidential Commission on the Supreme Court, a bipartisan group of experts on the court and the issues of court reform. He's written about a whole range of different issues in the context of democracy under threat, and among those issues are voter suppression, gerrymandering, and why marginalized people lack power in the U.S. democracy. In his project at the American Academy, which is entitled, this is, how do you say brackets? This is not bracketed, not a white man's government, the 15th Amendment and the Constitutionalization of democratic self-governance. He traces competing conceptions of self-government over 2 centuries of English and American political thought, culminating in the adoption of the 15th Amendment in 1869. I'm going to hand over the podium to Bertrall in just one moment, but I want to briefly explain the rules of engagement for this evening, both for the in-person and for our Zoom guests. For those of you in the room, pretty straightforward. If you have a question, raise your hand. And please wait for the microphone. For those who are joining us by Zoom, please do not raise your hand. No one will see it. Please do not click on the raise hand button either. Type your questions into the Q&A area on the Zoom screen, and you can start now if you have questions already. We apologize in advance if we can't get to all the questions, but we will share them with Bertrall, and he will be able to get back to you if he thinks it's appropriate. So with that, Professor Ross, the podium is yours.
Hello, everyone. Wow, this is the first talk I've ever given after a couple glasses of wine, so we'll see how this goes. It should be interesting. Thank you, Dan, for the kind introduction. It's lovely to be here at the American Academy. It's been an incredible semester for me, both personally and intellectually. Having a chance to meet and interact with the staff of the Academy and, of course, my co-fellows who I have developed a friendship and bond with that I very much value and appreciate. And I thank you all for the new folks I haven't met before, and I've had a chance to talk to some of you during dinner, and I look forward to your comments and feedback after the talk. So the starting point for my presentation is a 2013 United States Supreme Court case of Shelby County v. Holder. The case involved the question of the constitutional validity of a central provision of the Voting Rights Act of 1965. Section 5 of the Act required that states with a history of discrimination obtain pre-approval from the federal government for any changes that they make to their voting qualifications, standard practices, or procedures. Those states with a history of discrimination were mostly the southern states of the old Confederacy. And those states could only obtain pre-approval from the federal government for any voting change to any changes to their voting laws if they could show that the change did not have the purpose, it would not have the effect of discriminating on the basis of race. The importance of Section 5 arises from its shift of the burden of proof. Ordinarily, individuals seeking relief under a federal statute that prohibits discrimination have the burden of proving that the state law discriminates against them. But under Section 5, the burden is on the state to prove that a change to its voting law does not discriminate in violation of federal law. It was thought that this shift of the burden of proof to the states that the federal government was able to effectively block hundreds of potentially discriminatory voting laws and deter hundreds, if not thousands, more. Section 5 of the Voting Rights Act has thus proven to be one of the most effective civil rights provisions in the history of the United States. The evidence of its effectiveness can be seen in the fact that the black-white voter registration gap in the southern states subject to Section 5 has narrowed from 44.1% in the months preceding the act to near parity at the time that the court decided Shelby County. Accompanying those increases in voting registration were gains in turnout and office holding, with many viewing the election of Barack Obama as a crowning achievement of the act. Despite the success of the Voting Rights Act, Southern states objected vehemently to the act, arguing that Congress exceeded its authority when it made states obtain pre-approval from the federal government for any voting change. The states grounded their argument in the original federal Constitution adopted in 1789. The federal Constitution granted to states the authority to set voting qualifications and to establish the time, place, and manner of elections, although Congress had some supervisory authority over the latter. The federal government, however, defended the Voting Rights Act as a constitutional exercise of its powers under the 15th Amendment. Section 1 of that amendment prohibits the United States or any state from denying or abridging the right to vote on account of race or color. And Section 2 of that amendment gave to Congress the authority to enforce that prohibition contained in Section 1. For nearly half a century, the Supreme Court upheld the Voting Rights Act against repeated constitutional attacks from state and local authorities. But that all changed in the 2013 case of Shelby County v. Holder. In that case, a majority of the court determined that the Voting Rights Act's current burdens on state authority were no longer justified by the current needs of minority voting rights. The court, citing registration and turnout figures from elections in which Barack Obama was on the ballot, found that African Americans had reached parity with whites in registration and turnout, and that Latinos and Asian Americans were not far behind. The court had also alluded to gains in a minority office holding. However, it was clear that those office holding gains were far less impressive or important to the decision than the racial parity in turnout and registration. In contrast to the black-white parity in turnout and registration, there continued to be major racial disparities in office holding. Minorities, which comprised nearly 40% of the U.S. population at the time of Shelby County, held only 23% of the seats in the Congress, less than 15% of state elective offices, and less than 10% of local elective offices. And things are only slightly better now. If office holding mattered to the court, then the lack of proportionality should have been an important source of ongoing need for the Voting Rights Act of 1965, but it wasn't. And then there are the indications of political power that the court entirely ignored, such as whether racial minorities had achieved proportionate substantive representation in the political process and had secured equal opportunities to participate in other important ways. Evidence from social science suggests that minorities continue to lag on both accounts. According to a series of studies, the interests of racial minorities, and particularly African Americans, are underrepresented in the political process even after accounting for their minority status. In a study that accounts for the numerical strength of different racial minority groups, Viviana Rivero Burgos found that when grouping all policy issues and legislators together, white opinion is the most strongly associated with legislators' votes, followed by Latino opinion, and lastly, black opinion. Another study by John Griffin and his co-authors found that blacks are significantly less likely than whites to be policy winners, even after controlling for other variables, including population size. Thus, registration and turnout parity has thus far failed to secure equal substantive representation for minorities in the political process. One reason is that minorities and whites remain unequal participants in the political process. A critically important component of democratic participation in the United States that the court often ignores involves contributions to campaigns. According to a forthcoming study by Abe Anasia and Jacob Grumbach, 91% of individual campaign contributions to state and federal candidates between 1980 and 2012 came from white donors, which of course means that only 9% came from minority donors. This racial disparity in campaign contributions matters because such contributions have been shown to be an effective tool for influencing lawmakers. The ongoing disparities in minority office holding, substantive representation, and other forms of participation ultimately did not influence the court's assessment of the current needs for Section 5 of the Voting Rights Act, as the court ultimately nullified its effects. And the question is why? I think the answer is rather clear. For the court, the right to vote, protected by the Voting Rights Act and its parent constitutional provision, the 15th Amendment, appears to merely encompass the right to cast a ballot. As a result, the only important measure of equality for the court is voter registration and turnout. Whether parity in registration and turnout translates into proportionality in office holding, equal representation, or equal influence on elected actors does not seem to matter to the court's assessment of voter equality. My book project asks the question, what is the meaning of the right to vote protected under the 15th Amendment from discriminatory denial or abridgment? If the right to vote only includes the right to cast a ballot, then as suggested by the court, much of the work under the 15th Amendment and the Voting Rights Act appears to be done. The widespread and systemic political inequality that persists between whites and minorities could not therefore be redressed by the Constitution or the exercise of congressional power under the Constitution. Instead, we would have to just hope for progress towards equality to occur without the benefits of federal law. But if the right to vote means something more, then it becomes the constitutional responsibility of the court, and it introduces the constitutional opportunity for Congress to redress sources of political inequality beyond registration and voting. Now, a clue about the meaning of the 15th Amendment right to vote is provided in the period immediately preceding the congressional adoption of the amendment. The 15th Amendment was the most controversial and hotly debated of the three Reconstruction amendments that followed the Civil War. The so-called radical Republicans were the major driving force behind the amendment, and they were motivated by two primary sources. First, as members of the party of Abraham Lincoln, they were motivated by the desire to secure the complete emancipation of slaves. For the Republicans, part of the Emancipation Project involved extending constitutional protections to the political rights of the newly freed slaves so that they could protect themselves through the exercise of political power. Second, the Republicans also had a more instrumental political reason for their support of the amendment. The post-Civil War Republicans were also a sectional party that derived most of its support from the North and the West. Since African Americans comprised the majority of the population in some of the southern states, the Republicans saw their enfranchisement as a means of securing a constituency and ultimately elective offices in the South. On the other side stood the Democrats, who remained throughout adamantly opposed to the protection of African American political rights. Throughout the debates on the constitutional protections of African American political rights that began in 1865 and continued until the adoption of the 15th Amendment in 1869, the Democrats repeatedly offered a revision of Abraham Lincoln's Gettysburg Address. In the Gettysburg Address, Lincoln famously honored the soldiers for their sacrifices during the Civil War to ensure that government of the people, by the people, for the people, shall not perish from the earth. In their revision, the Democrats expressed a fear about something else perishing, the white man's republic. In the debates, the Democrats repeatedly asserted, this is a white man's government, a government of the white man, for the white man, and by the white man. And according to their terms, there was no place for the black man in the American Republic. Between the conclusion of the Civil War in 1865 and the election of 1868, Republicans held a supermajority of congressional seats. And that was enough seats for the Republicans on their own to pass an amendment protecting African American voting rights, but they could not agree on the language of such an amendment. That all changed with the election of 1868. As a result of the readmission of some of the rebellious southern states into the Union, Democrats secured enough seats in the House of Representatives to deny to Republicans the two-thirds supermajority necessary to pass an amendment protecting the voting rights of African Americans. However, in that era, there was a 4.5-month gap between the November election and the seating of a new Congress in early March. And it was during this lame duck session of Congress that the radical Republicans made a final push for the passage of the 15th Amendment. Now, in this final push, the House of Representatives passed a version of the amendment that said, the right of citizens of the United States to vote and hold office shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. And the Senate then followed up with their own version of the amendment that said the right of the citizens of the United States to vote and hold office shall not be denied or abridged by the United States or by any state on account of race, color, nativity, property, creed, or a previous condition of servitude. For the constitutional adoption of the amendment, a two-thirds supermajority of both houses would have to agree on an amendment with the same language. Ordinarily, differences in constitutional amendment language is worked out through a deliberative process in which versions of the amendment are debated and go back and forth between the two chambers of Congress. But in the lame duck session, there was no time for that. Only 3 weeks remained in the lame duck session when the two versions were passed, and so the two houses did something that had never been done before and has not been done since. The leaders of the two houses sent the two versions of the amendment to a conference comprised of select members from the House and the Senate, who were responsible for resolving the differences in language and delivering a compromise amendment to the two houses for a vote. And a week later, the conference produced a compromise amendment that said the right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Within a week, and after very little debate on the compromise amendment, both houses passed the amendment with a two-thirds majority. Now, there are no records from the proceeding of this House-Senate conference, so all we can do is speculate about the decisions made. One decision doesn't seem to require much explanation. The senators acceded to the representatives' preference to not include language protecting against discriminatory denial or abridgment of the right to vote on account of nativity, property, or creed. A primary basis for this opposition to these additional voting rights protections was the prejudicial attitudes towards Chinese immigrants on the West Coast that both Republicans and Democrats sought to exclude politically. But the House Senate conference made another change that is much harder to explain because it did not seem to be necessary. Both the House and Senate versions of the amendment protected the right to hold office, but the House and Senate conference version excluded such protections. Why? Now, the conventional explanation that is consistent with the Supreme Court's current jurisprudence is that the House-Senate conference narrowed the amendment to only protect the right to vote, defined narrowly as the right to cast a ballot, and to deny protection to other political rights, such as the right to hold office. But this explanation is ultimately question-begging. Since a supermajority in both houses passed a version that included the right to hold office, why did the conference committee deem it necessary or appropriate to exclude the protections from the amendment? An alternate explanation answers both questions. According to this explanation, the House-Senate Conference Committee removed the hold office provision because they considered it redundant. There was no need to protect the right to hold office separately because the right to vote encompassed all other political rights, including the right to hold office. And furthermore, the conference committee participants were concerned that including the right to hold office in the amendment might be construed as limiting the amendment's reach to the act of casting a ballot and holding office, when it was intended to protect much more. To the extent that the House and Senate excluded the right to hold office for this reason, then it would appear that the conference committee rightly exercised its authority to exclude the hold office provision. But how do we really know? I argue that in order to know, or at least put the thumb on the scale of one explanation over the other, we need to understand how the right to vote was conceptualized at the time of the adoption of the 15th Amendment. Was the right to vote generally understood to encompass other political rights, including the right to hold office, to be represented, or to participate democratically through means other than casting a ballot? Or did the right to vote really only refer to the right to cast a ballot? In order to understand the meaning of the right to vote at the time of the amendment's passage, we need to understand how Americans conceptualized the governing framework in which the right to vote was embedded. And that governing framework was the Republican form of government. Republicanism as a governing framework is currently associated with democracy, in the idea that the people govern through their representatives. But historically, this is not how republicanism was always understood. For much of history, the meaning of republicanism was malleable, as it was often associated with governing, in whatever form, for the public good. One of the only constants in republicanism was its opposition to arbitrary, absolutist, and self-aggrandizing forms of rule, most commonly associated with European empires and monarchs. Theorists therefore comfortably associated republicanism with aristocracy, even limited monarchy that did not carry these arbitrary and absolutist features. For many theorists, the best form of government for promoting the public good was a mixed form of government in which monarchical, aristocratic, and democratic elements shared governing authority, each with the power to check the other. And within this mixed form of government, theorists such as Machiavelli, Michael Harrington, Algernon Sidney, and John Locke favored a form of republicanism in which the aristocratic elements were the key holders of power. For these theorists, Sparta, Venice, and Rome, in which aristocratic senates held most of the power, represented the favored Republican models. Republican theorists favored these aristocratic institutions because they were viewed as serving a critical balancing function against the absolutist tendencies of the monarch and the supposed anarchist tendencies of democratic elements. In these aristocratic conceptions of republicanism, the few, usually in the guise of hereditary nobles, ruled over the many. And political power was derived not from the vote, but rather from economic power. While aristocratic republicanism was a dominant view, a distinct minority of Republican theorists from the classical period to the early 19th century advocated for a more democratic form of republicanism. These theorists included mid-17th century English levelers and a turncoat theorist by the name of Marchemont Needham, who championed leveler political philosophies when conditions were favorable to the levelers, and royalist political philosophies when they were not. For those theorists, the democracy of Solon's Athens and the Roman tribunes were the favorite Republican models, while Sparta and Venice were, in the words of Needham, models of government in which the people were no better than slaves under the power of their senates. Under the more democratic conception of republicanism, the vote, and not economic power, served as the chief instrument of political power, and served as the principal means by which the people participated in government. In a smaller Athenian type of republic, the vote was a tool that the people used to participate in the creation of rules, policies, and laws. And in the brief incarnation of the larger English republic, the vote was a tool that the people used to select their agents or servants, who were responsible for adopting laws, rules, and policies according to the instructions of the people. In this democratic conception of republicanism, there was no privileged class of rulers or subordinate political subjects. All who were considered members of the polity had an equal right to participate in all forms of governing. They also had an equal power to rule through the democratic conception's embrace of majority rule. Now, it's important here that I stop and acknowledge a critical caveat about the democratic conception of republicanism. Under that conception, the opportunity to participate in political equality only extended to those who were considered to be part of the polity. Excluded from membership, of course, was an overwhelming majority of the people, including women, paupers, slaves, children, and sometimes those that lacked property. Thus, even the democratic version of republicanism was ultimately grounded in the rule of the minority. But among that minority, there were none of the aristocratic distinctions between classes based on economic power, and there was an association of the vote with the broader authority to govern. Thus, when conceptions of the polity expanded under the democratic conception, it required that the vote and the broader authority to govern be extended to the new entrants. In popular historical mythology, the United States emerged from colonial rule as a democratic republic. Many point to the Declaration of Independence, which contains all of the indices of republicanism as evidence. It proclaims the natural equality of the people and endows them with rights. Can you guys read that? No, I'm just kidding. Y'all weren't supposed to. Play. It's the wine. In the famous words of the Declaration, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. The government, according to the document, derives its powers from the consent of the governed. And the people, the document suggests, have a right to self-government that includes the right to alter or abolish a government, and to institute a new government laying its foundations on such principles and organizing its powers in such form as to them shall seem most likely to affect the safety and happiness. The Declaration's aspirations for a more democratic form of republicanism also found their way into the Bill of Rights as states incorporated into their first constitutions during and after the American Revolution. And some of these were even more explicit in their embrace of the democratic conception of republicanism. Perhaps the most influential in the early American state constitutions, the Constitution of Massachusetts, advanced the principle of democratic republicanism in its Declaration of the Rights of the Inhabitants of the Commonwealth of Massachusetts. After proclaiming the natural equality of man, the Declaration asserts, the people of the Commonwealth have the sole and exclusive right of governing themselves as a free, sovereign, and independent state. It then defines the relationship between the people and their magistrates when it says all power residing originally in the people and being derived from them, the several magistrates and officers of government vested with authority, whether legislative, executive, or judicial, are the substitutes and agents of the people and are at all times accountable to them. And finally, the Declaration of Rights rejects distinctions between the governed and governors when it says all elections ought to be free, and all the inhabitants of this Commonwealth, having such qualifications as they shall establish by their frame of government, have an equal right to elect officers and to be elected for public employments. Another important early state constitution, the Virginia Constitution of 1776, contains similar language in support of democratic conception of republicanism, and is even more explicit in its embrace of political equality. Section 3 of the Bill of Rights expressly proclaims that a majority of the community hath an indubitable, inalienable, and indefeasible right to reform, alter, or abolish the government in such manner as shall be judged most conducive to the public weal. Although Massachusetts, Virginia, and several other states with constitutions contain language professing adherence to the democratic version of republicanism, the governments that emerged after the Revolution were more aristocratic than democratic. Following the democratic aspirational statements in the preambles and Bill of Rights, the state constitutions explicitly linked economic power to political power in the following ways. First, nearly every state constitution established property qualifications for voting, limiting participation to those who held certain amounts of property. Second, some of the states established distinct ruling classes comprising the property elite by establishing higher property qualifications for office holding than for voting. And finally, several states and one or both of their political bodies apportioned seats on the basis of property, or a combined basis of population and property that yielded to the property classes disproportionate political power. Some of these provisions, such as the property qualifications, were relics from the colonial era. but others were newly constructed with the purpose of empowering the property elite and establishing the group as a separate ruling class in accordance with the aristocratic version of republicanism. The goal of this aristocratic republicanism was to protect property held by the elites from the masses. John Adams, a principal drafter of the Massachusetts Constitution, advanced a justification for aristocratic republicanism grounded in property. He wrote, "Suppose a nation, rich and poor, high and low, 10 million in number, all assembled together, not more than 1 or 2 million have lands, houses, or any personal property. If all were to decide by a vote of the majority," Adams surmised in the form of a question, "do you think the 8 or 9 million who have no property would not think of usurping the rights of those 1 or 2 million who have? Debts would be abolished first, taxes laid heavy on the rich and not at all on the others, and at last a downright equal division of everything be demanded. What would be the consequences of this?" Adam asked. "The idle, the vicious, the intemperate would rush into the utmost extravagance of debauchery, sell and spend their shares, and then demand a new division of those who purchased from them." Adams concluded, "The moment the idea is admitted that property is not as sacred as the laws of God, and that there is not a force of law and justice to protect it, anarchy and tyranny commence." So here we see the age-old association between democracy and anarchy that the framers of the American Constitution also took to heart in the construction of the federal Constitution. The framers of the federal Constitution went even further than the states in establishing an aristocratic body that they intended to be comprised of the property elite, who would be subject to limited democratic accountability. First, the framers established long terms for the Senate, with the initial proposal of lifetime tenure being compromised down to 6 years, which was still longer than any state elected official's term. And second, the framers denied the people the opportunity to directly elect senators, instead delegating such authority to state legislators. Even with these protections of aristocratic power, the framers were still concerned that the government might not be sufficiently protective of property. They therefore sought to bring aristocratic sensibilities to the House of Representatives as well. The framers were smart enough to recognize that in order to obtain popular approval for the Constitution, they would have to establish a House of Representatives that would be subject to popular elections. So they focused instead on methods to dilute the electoral influence of the people through other constitutional designs. At first, the framers attempted to follow the lead of the states in establishing property qualifications for voting in federal elections. Unable to agree on the level of property qualifications, they ultimately delegated to the states, many of whom maintained property qualifications, the authority to set qualifications for voters in federal elections. In addition, as part of the compromise with the slaveholding states in the South, the framers followed the lead of some states in using property as a basis for allocating power. Article 1, Section 2, Clause 3 of the Constitution provided for the apportionment of representatives on the basis of the whole number of free persons and 3/5 of all other persons. These other persons were, of course, African Americans held in bondage and treated as property. The 3/5 clause therefore provided a property basis for enhanced political power in the House of Representatives and would be later used by slaveholders in the South as a justification for allocating political power on the basis of property. For nearly the next half century, aristocratic republicanism would remain a defining feature of American constitutionalism at both the federal and state level. In this era, consistent with the English Republican models of Michael Harrington, Algernon Sidney, and John Locke, political power followed from economic power. The vote under the aristocratic version of republicanism was understood to be a tool held by the few, used only to select rulers from an even smaller class of the economic elite. The vote, therefore, was not equated to political power, influence, or representation. Instead, the vote was subordinated to property as a means by which the people asserted power and influence over government and secured representation from government. This would all start to change with the emergence of a populist egalitarianism most commonly associated with President Andrew Jackson in the 1830s. At the national level, this populist egalitarianism promoted a democratic version of republicanism for white men and rejected the founding era aristocratic version of republicanism as anti-republican. In this era, the vote gradually replaced property as a primary instrument of political power in 4 ways. First, most states extended the right to vote to a broader class of propertyless or property-deficient white men. Second, political offices that had been filled by appointment were made elective. Third, property-based restrictions on office holding were loosened or eliminated altogether. And finally, states shifted from allocating political power on the basis of property, or the combined basis of property and population, to allocating political power on the basis of the people alone, which led to a more equal distribution of political power among the people. Accompanying these changes was a changing understanding of the American frame of government and the political philosophy that undergirded it. These changes were most clearly evidenced in the constitutional conventions that produced these changes. The state constitutional conventions of the first half of the 19th century contained rich, detailed debates regarding the proper understanding of American Republican government, whether American Republican government is best understood in aristocratic or democratic terms. And I can spend hours retelling the stories of these interesting debates. But unfortunately for me, fortunately for you, I do not have hours, and to avoid the risk of further losing your attention, I'm going to focus briefly on the debates in Virginia, just to give you a flavor of the diverse appeals to republicanism that were made during this era. In Virginia, the debate centered on how to properly allocate political power in the legislative department. The 1830 Virginia Constitution allocated power in a way that favored the property-holding elite at the expense of the emerging popular majority in the West. And the question was whether this more aristocratic allocation of political power should continue, or whether a more democratic allocation of political power should replace it. The slaveholders of the East ultimately won the debate, preserving aristocratic Republican features in the Constitution, but not before it was subject to serious challenge that ultimately resulted in the West seceding from the rest of Virginia and forming the new state of West Virginia at the beginning of the Civil War. In the debate during the Constitutional Convention of 1851, the Easterners, on the one hand, represented the views of Southern slaveholders, who sought to retain political power to protect the peculiar and degrading institution of slavery from too much taxation by the non-slaveholding majorities in Southern states. The Westerners, on the other hand, represented not only the views of many non-slaveholders in the South, but also those of Republicans in the North, who serially repudiated, in amendments to their Constitution, property bases of political power in favor of popular bases of political power through the vote. The debate in Virginia is a microcosm of the debates in several American states over the proper form of republicanism, which implicated the value and meaning of the vote. Now, starting with the perspectives presented by the slaveholders of the East. At the beginning of the convention, slaveholder Robert Eden Scott from the eastern county of Fauquier introduced a proposal in the convention that would preserve a property basis for representation. For him, it was without question that if you pay most of the taxes, you shall enjoy most of the representation. Property, he argued, is entitled to protection, and with the only adequate protection being representation in the legislative body. Scott criticized the advocates of more democratic conception of republicanism for their failure to recognize the anti-democratic roots of republicanism in America. No set of men on earth were ever more deeply impressed with the dangerous tendencies of the democratic spirit, Scott explained, than the founders of our American system, or ever more sedulously guarded against the evil which it threatened. He noted that the debates in the Federal Convention showed that members most friendly to a liberal plan of government were as loud as any in their denunciations of the vices of democracy. And the Federal Constitution shows, throughout its provisions, numerous and stringent checks upon that unlicensed popular will out of which all these vices spring. Scott identified the manner of electing the president, senators, representatives, and the manners of constituting the judiciary as examples of the anti-democratic features of the U.S. Constitution. Scott therefore concluded, if therefore the government of this state be anti-republican and aristocratic, that of the United States is eminently so. And instead of appealing to the principles of our fathers, the gentlemen ought to hurl their loudest denunciation against their works. The slaveholding aristocrats rejected any connection between the Virginia Declaration of Rights and the principles underlying democratic republicanism. Absolute individual political equality, in the words of an Eastern delegate by the name of George Perkins, is a perfect absurdity. You cannot affect equality. Inequality must exist. It always has existed and it always will exist. It exists in every community, in every nation in the world. You have in society the rich and the poor, the weak and the powerful, and these different grades of necessity must continue to be. Perkins concluded, you cannot organize a good government without this inequality existent. You must have this inequality that is political, natural, and social. Now, what does this all mean in terms of the value and meaning of the vote? Here, an interesting division emerges between the Eastern delegates. Richard Beale from the Eastern County of Westmoreland appears to concede, on the one hand, that the vote involves the complete exercise of political power as he directly connects suffrage to representation when he defines suffrage as political power in the concrete and representation as political power in the aggregate. But then, consistent with the arguments of many Northern aristocratic Republicans, he argues for inequality in or restrictions upon suffrage for the purpose of protecting property against the indigence and want of individual men. And he justifies the inequality and representation that would result from this restriction on suffrage as necessary to protect the property-holding masses of a community from the plundering propensities of the other masses. Beale concludes, it is to protect property that government was first organized. As such, restrictions upon suffrage are designed to protect capital from labor, inequality of representation to balance and harmonize the conflicting interests in property itself. George Perkins, on the other hand, advanced an alternative view of the vote that was held by many of the Southern aristocratic Republicans, when he rejects the argument that the right of suffrage serves as the groundwork for representation. For Perkins, the exercise of the right of suffrage is only one of the elements of representation for which power is a part. The right of suffrage alone, he explains, does not give power. It is the exercise of a political right incident to citizenship, but it is not the only means by which political power is created. Here, the clear implication is that property is the other means by which political power is exerted, and to which representation must also be given. For the aristocratic Republicans, the property white men properly hold disproportionate power through either restrictions on the vote delegated to the non-property white men, or by devaluation of the vote that was delegated to the non-property white men. For the Western Virginians, the Easterners' promotion of aristocracy were anathema to the democracy that they argue was at the core of republicanism. The arguments of the Westerners were grounded in the Virginia Bill of Rights that they associated with democratic republicanism. William Smith of the Western County of Greenbrier declared, "Nothing is more apparent to my mind than that the existing government violates the great principle of political equality so essential to a representative Republican government, that it is aristocratic in all its features, that it prostrates in dust those invaluable truths which have been wisely embodied in the Declaration of Rights." For Smith, the doctrine of qualified white voters as the only true and legitimate base of representation lied at the foundation of all free government, and without it, there could be no rational, well-secured, or well-regulated liberty. Another delegate from the West, William Brown, wholly repudiated the doctrine of wealth being an element of political power. He recognized the duty of society to guard carefully the right of property both by constitutional provisions and legal enactments, but should never give money the power to rule men. Even though many Westerners condoned slavery, they rejected the idea that slavery required the aristocracy of the slaveholding elite, and the idea's concomitant connection between economic and political power. In the words of the Western delegate William Lucas, a miscalled Republican government with almost unlimited power in the hands of a sectional minority upon a slave basis is degrading to freemen, whom it excludes from the enjoyment of their rights and is little better than a limited monarchy. Our fixed, unchangeable convictions, Lucas asserts, is that no government is truly Republican that is not based upon the people, that one based upon numbers and wealth combined is not Republican, as it places the power in the hands of the wealthy minority and is an aristocracy. Beyond rejecting the argument that slavery required aristocracy, the Westerners suggested that aristocracy posed a threat to the continued Western support of slavery. Western delegate Waitman Willey recognized that the debate between aristocratic and democratic conceptions of republicanism were long-standing. It is the same struggling effort continuing through centuries past to centralize power in the hands of the few against the antagonist struggles of the many to have it diffused broadly in the community. It is the same old contest that has been convulsing the world ever since the world was populated, the struggle between the money power and the many power. For Willey, the question will arise, when you make your slaves as a subject of taxation the instrumentality of political and personal inequality in the government, can it be expected that men will ardently and cordially support slavery when by so doing they are virtually cherishing the property which is making slaves of themselves? Will not the hostility to slavery be endangered by the incorporation of such a principle into the Constitution? Willey asked. Now, despite the pleas of Willey and other Western delegates, the Virginia Constitution of 1851 maintained an aristocracy of the property elite. Although the Virginia Constitution extended suffrage to a broad class of white men, the aristocracy continued as the individual vote was devalued by the system of representation that favored the property elite. And Virginia was not alone in preserving the aristocratic form of republicanism, as its sister state of South Carolina did so as well, and a couple others in the South too. But these slave states were in the distinct minority at the initiation of the Civil War, as northern and western states adopted democratic Republican frames of government. In these democratic republics, the Constitution treated the vote as a chief instrument of political power that was distributed more equally among the white male members of the polity and provided these white men with the opportunity to equally participate and to be equally represented in the government. So with this history, we can now reframe the question about the meaning of the 15th Amendment. Did the framers and ratifiers of the amendment mean to reconstruct a Republican aristocracy, this time along racial terms? In other words, did the framers and ratifiers of the 15th Amendment mean to protect merely the right of African Americans to select their rulers and to permit the establishment and maintenance of state laws that would allow for the unfair and unequal distribution of political power between whites and blacks? I think the history clearly suggests the answer is no. The radical Republicans that adopted the amendment in Congress and the mostly northern ratifiers of the 15th Amendment shared the political philosophy of democratic republicanism that rejected aristocratic maldistribution of political power. For them, the vote was a tool that gave all who held it the complete panoply of political powers. Those democratic republicanism designed the prohibitions under the 15th Amendment to protect the exercise of political power in all forms from racial discrimination, whether it be casting a ballot, holding office, being represented, or participating democratically in other ways. And they did so in hopes of avoiding the recreation along racial terms of the Republican aristocracy that they and their predecessors fought so hard against. Returning to the current day, does this account of the meaning of the 15th Amendment mean that the Supreme Court got it wrong in Shelby County when it narrowly construed a key provision of the Voting Rights Act as merely protecting the non-discriminatory right to cast a ballot? I think that question ultimately turns on congressional intent. And although I think that Congress was clear in its 1982 amendments to the Voting Rights Act that it intended to protect not only the equal right to vote, but also the equal right to representation in office holding, I recognize that people might disagree. But even for those who think that Congress and the Voting Rights Act intended only to protect the non-discriminatory right to cast a ballot, the more important point derived from the history of the 15th Amendment is that Congress has the authority to protect from racial discrimination the wider array of political rights embedded within the 15th Amendment. As a reminder, Section 2 of the 15th Amendment says that Congress shall have the power to enforce this article by appropriate legislation. In that article, the 15th Amendment protects the right of the citizens of the United States to vote from denial or abridgment on account of race, color, or previous condition of servitude. Congress can, and I argue should, use this authority to pass legislation targeting the remnants of the racial aristocracy in America by directly protecting against discrimination not only the right of minorities to cast ballots, but also to hold office, to be represented, and to contribute to campaigns. It is only by breaking down and truly repudiating the racial aristocracy that something closer to true racial equality can be achieved. Thank you for your time and attention. I look forward to your feedback.
You haven't had a chance to engage Justice Roberts on this one yet.
No, we haven't had a talk. We're set to have a call tomorrow, probably.
Oh, yeah, okay.
That actually gets at the heart of my question, which is, have you had much chance to engage with the actual legislators on essentially you're presenting an argument for a change to the 15th Amendment? So, what is your intuition about how this will be received? And do you have a plan for sort of getting the word out about this?
Yeah, no, it's the last time I had conversations with Congress members was right after the Shelby County decision. And the question was, what do we do now? How do we protect voting rights after the Voting Rights Act has been essentially nullified, or the important provision of the Voting Rights Act? And what was so discomforting for me was a sense of disempowerment that Congress members felt. They said, well, the court said this, so we can't do anything because the court said this, right? And I think that what they bought into was kind of the narrow understanding of the vote that the court put forth. They tried to, suggest that, well, we've reached parity of registration and turnout, but we haven't come all the way, right? That was the Obama elections. It could change, right? They weren't thinking capaciously about how the right to vote might be construed and understood. And so it was essentially giving up on it. There was some work afterwards to try to adopt or try to put together a revised amendment. There's a bill before the House right now called the John Lewis Voting Rights Act that would amend Section 5, but very little momentum, and Republicans aren't willing to go along. And there's a sense that that bill is even limited in its reach because of what the court has said. And so I think that this project has been kind of in development for a decade, right? And something that I just have never gotten around to. I appreciate the American Academy for giving me this opportunity to do this. And what I hope to do, now that I've started to understand what the 15th Amendment means more broadly, is to have a conversation with many of those same Congress members to understand their authority with respect to voting rights legislation. Now, in our divided politics right now in which the filibuster acts as a block for any action in the Senate, and the Republicans hold enough seats to block any action because of the filibuster, I'm not expecting, or I'm not optimistic about any progress. But if the filibuster were ever to go away, or the Democrats were to get a supermajority, I hope that this will open their minds to the possibilities of what type of legislation they could pass. They shouldn't be sort of narrowly bound to what the Voting Rights Act was, because as the Voting Rights Act was the most effective tool of civil rights policy in history, but there's still so much more that can and needs to be done. And my goal is by, when I get this book hopefully developed and published, that this will be a part of a conversation starter that will help Congress think more expansively about its power and its role in constructing a truly inclusive multiracial democracy.
Can I just follow up on that? Because this is a problem that's dramatically evident in Shelby.
Yeah.
But it's also a chronic part of our political culture that the Congress looks at Supreme Court rulings and just says, "Oh well, that game's over."
Right.
I mean, it's true on gun rights, for example, which we've seen over and over again. Even though, most of the scholarly literature suggests that the jurisprudence on gun rights has just changed dramatically over decades.
Right.
What do you have to do to get a congressman to realize he has power?
Yeah,
or congresswoman or anyone.
What's so interesting is how much this has changed, right? You kind of go back to the 1930s and when there was this extreme conflict between a New Deal Congress and president and the courts, in which the courts were actively striking down New Deal legislation designed to help get the economy out of the Depression. And the response to Congress was very different then than it is now. The response to Congress was frustration at the court, but to keep pushing, right, in the sense of keep passing legislation designed to address this problem, even against the possibility that the court might strike it down. And the Congress has kind of taken a different role now. They've been deterred by court decisions to even attempt legislation that might redress these problems. And I think that Congress has to get out of this mindset. I think judicial supremacy and the idea that the court is this kind of supreme actor with respect to the meaning of the Constitution has taken such a strong, firm hold on Congress members that they feel very deterred from acting in ways that might even come close to the constitutional line that the court has fuzzily drawn. And I think that it's important for Congress to reclaim its constitutional role for which it has. I showed you Section 2 of the 15th Amendment, which says Congress has the authority to enforce this legislation by appropriate legislation. That provision exists not only in the 15th Amendment, but in several other amendments as well, giving Congress a primary authority over these matters. And I think it's time for the Congress to reassert the authority and to challenge the court, right? To confront the court in the sense of, if you force the court to, in a sense, play its hand and strike down the legislation if it so chooses. And I think that if Congress were more aggressive in that way, that you would find a court that would be less willing to be as proactive in striking down laws. I think the court got a lot of pushback with it striking down a Shelby County. And I think that if you respond with a law that pushes the ball, right, and seeks to protect voting rights in an aggressive way, but maybe slightly tweaks things a little bit to respond to Shelby County, I think the court would be hard-pressed to keep engaging in that process of striking down democratically enacted laws. But I don't know how you get Congress to reclaim that confidence in itself as a constitutional actor. It doesn't have that confidence right now. I think in part because the court has been such a popular institution. That's starting to wane right now. So maybe that will change the dynamic between Congress and the court. But I think that will be critical for the future of protecting voting rights or civil rights more broadly in the United States.
So is this ironically an unintended consequence of Brown and other really popular rulings?
Yeah, it's interesting, right? Because you have the liberal embrace of the court for so long, right? The Warren Court is, kind of the representation of good judicial policy and righteous judicial policy. And that, I don't want to denigrate it as worshiping of the court, but the elevating of the court to this stature of chief lawmaker in our society has had the unforeseen or perhaps foreseeable consequence that the court has taken on this role, right? And has garnered the respect in the past across ideological lines, right? And Congress doesn't have that same level of respect. So when the court says something, it is honored more by the people than when Congress says something. And so, the court has put forth courageous decisions, Brown v. Board of Education perhaps being the chief example of them. But they've also made some very bad choices as well that we need to recognize and understand, and recognize that the court is not infallible, that the other institutions of government have a role and a constitutional responsibility, and that they need to continue to push their conceptions of the Constitution as well against the court's conception and see where we get to.
That's completely fascinating. Yanni, you had a question.
Is this working? Bertrall, thank you very much. It's always a pleasure to listen to you peel back layers of meaning and expose them for the listener. It's always a pleasure to sit back and listen. In this case, I think what you're saying, what it came down to is that the amendment was made so specific that in the end it was only an amendment about racial discrimination.
Right.
And then what we see subsequently is that Congress or the Constitution can be as specific as it wants. The courts can still find ways to strike it down, right, when it comes to practice.
Right.
And of course, this is, I think, one of the difficult situations we find ourselves in the United States now, in many regards, with the court ruling more or less, as you're saying, unilaterally. Yeah. But I found it also interesting that when it came to the other things that were taken out of the Senate's version, two of them struck me. One of them was property, and the other one was nativity, which were also taken out. And property, I thought, operated in an interesting way in the way you were exposing it to us. Yeah. Property, on the one hand, was a euphemism for race, or it was about race and slavery, but it was also an independent variable. It was also about class, it seemed to me. So just as, if this is unfair, ignore it, just talk about the rest of it. But what would we look like today if that had actually passed?
Yeah, that's a great question. And I'm glad you brought that up, because that's something I kind of took out of the talk as getting too long, but it's one of the more fascinating features of the amendment, the debate about property. And that was a big source of division, right? Because even though I think democratic republicanism and that idea had emerged as the leading idea by the time of the 15th Amendment, it was still a very classist republic, right? And there is still the idea that property meant attachment to land, stake in the community that was quite valuable and should be cherished. And therefore, eliminating any ability of the states to maintain property restrictions would take away their opportunity to ensure that the people there that had a stake in the land. But of course, it had been used throughout history as a way to construct an elitist democracy, right? So what would that look like now? I think that the ways in which it's operated since the 15th Amendment is that there have been enacted different forms of property qualifications, whether it be poll taxes, whether it be other forms of property qualifications, whether it be voter ID laws that require a certain amount of wealth and property to obtain these instruments of asserting. And I think that what would possibly happen, to the extent that the property qualification or the prohibition on property discrimination was taken away, and if it was interpreted as broadly as I think it could have been, it would have put the onus on the state to provide opportunities for participation for those who lack the means to participate, right? It would put the onus on the state to reduce the cost barriers to voting to nearly zero, right? You can't remove it entirely. You always have to go to a poll or something like that, but to reduce it to nearly zero, maybe it would make registration automatic, in which you don't require that they have a car or vehicle to go to the DMV or go somewhere to be registered and stuff like that, right? It could have been interpreted in a way that would make voting a lot less costly, and it could have sort of shifted our system to one in which you have a democracy that doesn't have these barriers on the cost side of things. There's still the benefit side of things. You still have to give people a sense that they have a stake in the election, that this election matters to them. But you could have reduced the cost side in important ways that might have enhanced participation across economic class lines. Because one of the persistent gaps that exist in American democracy is a 30% gap in turnout between the rich and the poor, right? Could that be fundamentally changed with a prohibition on property restrictions? Possibly.
Okay, well, I'm being pointed over here to you.
Alex got the mic.
To Alec McGillis. I thought it was Johannes Tim.
Bertold, that was great. I was curious about the citing of the 3/5 clause as evidence of this sort of property rights enhancing the the right to vote, enhancing political power. I've always thought of the Three-Fifths Clause as very much not that, as something that was all about numbers. So basically, we were apportioning power in the House and in the Electoral College based on population. So there was a question of how do you count these states? And because, like Virginia would say, we're a huge state. And the North would say, well, that's partly because you got a lot of enslaved people that you're not letting vote. And so... And then they came down to a 3/5 compromise to how do you count these people, because Virginia wanted to have them all counted because they would then have more power. So I thought of it as a demographic census, political numbers thing, and not so much a property rights thing. Although of course these enslaved people were property. It was more just how many seats are we going to get in this new government that we're creating?
Right. No, and that's how I thought of it too. But what I learned is that the Three-Fifths Clause emerged before the Constitution. It was already a compromise, but it was a compromise with respect to how much these states would be taxed under the Articles of Confederation. So you'd be taxed by according to your population. The larger population you have, the more taxed you would be. So it was the southern states who were trying to reduce and turn slaves into property in that respect. The northern states are saying, no, they're people, right? And so we're trying to count them. And so the compromise was ultimately, okay, we'll come up with 3/5 and we'll tax you accordingly, right? And so then we get to the talk about representation, right? And in representation, the southern states are like, oh, wait, they count as a full person. And the northern states, they don't count at all. And they're like coming back to the 3/5 provision. And so that's kind of how it emerged at the origins. But then when you get to the states, and they use this 3/5 clause as a justification for a property basis for allocating political power, right? And so even if it was understood in the terms that you describe it, it became reconstrued by the Southern slaveholders as saying, look, this is embracing the American Constitution, right? And surely we honor the people, our forefathers who constructed this amazing Republican Constitution, and therefore they embrace sort of a property basis for allocation power. We have too, and we should continue to do so. And so they ultimately reconstrued it in these debates in these property terms. And so that's kind of how this 3/5 thing came to be used, misused, reused in the different contexts.
Okay, over here.
Hi, I'm Dirk Schmalenbach, a lawyer, but with no constitutional experience at all. Your analysis was fascinating in analyzing the historical context of this amendment. I found it interesting from my limited, albeit German constitutional experience, that the focus was exclusively on the historical context of this provision coming into law. In my little world, one might have looked at other aspects of context, verbal meaning, other forms of interpretation, and a concept that is quite often applied by the European Court of Justice, the effet utile concept of looking at what is intended by a provision could play a meaningful role in this context. Now, I know that over years, a debate has taken place how the Constitution is constructed. Yeah. And I suppose you may have a liberal background. Has the liberal branch of constitutional jurists succumbed to the historical interpretation of the Constitution and its amendments?
Yeah, it's a great question, right? It's an ongoing debate that's going on in the United States between a more what they refer to as originalist methodology that draws from history in the understanding and interpretation of constitutional provisions, and what the originalist methodology that is most dominant right now is referred to as original meaning originalism, in which you're trying to understand how people at the time, what the people at the time understood a term to mean. Right? And you get that from the historical context that surrounds that particular amendment. And you can make the case that, some of what I'm doing fits within that methodological approach. But it's not the approach that many progressives or liberals take in the United States. They tend to be more oriented with what might be vaguely defined as a more living constitutionalism, in which you look to evolving values, evolving views of the people, and how that might have changed our understanding of or how and how those evolving views inform our understanding of the constitutional provision. So just to take an example, there's in the 14th Amendment a equality provision called the Equal Protection Clause. And the notion is that, equal protection at that time, the 14th Amendment had a more sort of confined and constrained understanding, right? It was a clause that perhaps allowed for racial segregation, right, in the sense that the Equal Protection Clause was adopted at a time when many states maintained segregation in schools, right? But over time, we came to understand equality should not embrace that policy. Now, how I engage in historical methodology is what I'm trying to do is derive a principle, a broad principle from the historical context of the amendment. And that principle here is really about sort of with equality. I think there's a principle of anti-subordination embedded within it, within this right to vote provision. I think it's also an anti-subordination, but it's also a capacious notion of political rights, right? Now, how equal political rights? But then when it comes to how that should apply, I don't think you should look historically. I think you look to the current context, right? And so when you think about applications back in this 18th century, right, maybe they're not thinking in terms of, the political rights and equal political rights extending to sort of some notion of campaign contribution equality, right, or even equal substantive representation. Maybe they're not thinking in those terms, but we've come to understand this broader principle of equal political rights as encompassing these things more broadly. And so in their application based on our evolving values, that should inform how those amendments should apply, what Congress's power should be understood to be under these amendments. So it's kind of a hybrid approach that I take. History to derive the principle, the current evolving values and context to understand how the principle should be applied.
Thank you very much. I have two short questions which I consider a bit German, but I dare to ask them. The first one is, I think your research is a bit motivated by the effects you fear by the deletion or by the abrogation of that Article 5 you exposed in the beginning. Could you elaborate a bit on the factual side of that? Because we are not familiar with what may follow if now you do not have that act anymore.
Yeah, for sure.
The second question is even more German. I'm not so familiar with your constitution, but I think the word race appears only in that article. That may be true. I'm not sure. It's not in the 14th Amendment. I tried to look that up. But we have an Article 3, subsection 3 in the German Federal Constitution, where the same term appears.
Yeah.
And there's a huge discussion to avoid it, to get rid of it, to replace it by something else. My question would be, does this affect your research in any way? Is there such a discussion in the States? Perhaps it deviates a bit from it, but then you elaborate more on the first question.
Yeah, sure.
Easier.
I don't know. Joy, does the 13th Amendment have race in it? I can't remember if it refers to servitude. Yeah. I think that's right. That's interesting. I hadn't thought about that. So let me start with the first question, and maybe my mind will work around to thinking about and providing an answer to the second one. So Section 5 of the 14th Amendment it was a pretty radical intervention. Now, it's radical in the sense that prior to this intervention, generally it was understood litigation to Protect Voting Rights Act operated like this. You would, if you felt like you were discriminated against, right, or if the government, as a government actor, felt like the federal government felt like the private or the state governments were discriminating, then you would litigate and you would sue the state for discriminating on the basis of race. But the burden would fall on you to prove such discrimination. So in the example of the southern state, the famous Dallas County in Alabama, which has as its home Selma, which is the point of the march from Selma to Montgomery that ultimately led to the momentum for passage of the Voting Rights Act. The Dallas County registrars had been engaging in pernicious actions against African Americans for many, many years. So they would have literacy tests that they would apply in ways in which college-educated African Americans had no chance of passing, but grade-educated white Americans would pass every time. And so they would operate in a discriminatory way. They would have understanding tests in which you would have to express an understanding of the Constitution that was purely discretionary, in which the registrar would decide if you understand the Constitution properly, in which, of course, African Americans never did, and white folks always did. And so you would bring litigation against the registrar for such discrimination, right? And even if the court found in favor of you, right, you would be able to prevent the registrar from acting in that particular way at that particular time, but then they could just do that same action or bring in another registrar to engage in that same action with another with future voters. And as a result of this direct litigation, which was being brought under 3 acts that preceded the Voting Rights Act, the 57, 60, and 64 Civil Rights Act, there was no progress, very little progress in registration. We went from Dallas County having maybe 1% of the African American voters registered in the 1950s before these litigation actions, and by the time litigation actions were done, we're up to 2%. And there's a recognition that we're not going to be able to get there through direct litigation this way. So we have to find a way to do it differently. And so what the big thing that they did differently was to say that any time you enact any voting law change, right? Anytime you seek to enact, first of all, they banned literacy tests for temporarily. And then any attempt to adopt something that would replace literacy tests would have to obtain pre-approval from the United States Department of Justice or the United States Attorney General. And they would decide whether this provision has the purpose or would have the effect of discriminating on the basis of race, right? And so that was a big blow to Southern efforts to disfranchise and block the vote, right? And over time, right, the biggest effect of Section 5 was deterring states. They wouldn't even try to make voting changes because they knew that the Department of Justice would ultimately strike down that voting changes. So they would have to maintain their system as it existed then, which included some barriers, but very reduced barriers than they were from before. And as a result, we see this dramatic rise in registration and later a dramatic rise in turnout. And so it's a critical provision. So when we get to the current day of 2013, well, there's this idea that, okay, we've reached this registration and turnout parity, but does that mean we don't need this act? If we define the vote narrowly as turnout and registration, the question is, do we need this act anymore? And the argument for the conservatives on the court was like, no, we're good. We've reached parity in these forms. But the liberals made the point on the court that, well, we've reached this parity because we have, in a sense, put an umbrella up, right? We are protecting ourselves from the rain. When you take that umbrella down, it doesn't mean the rain is going to go away. It's going to fall on you. That rain is going to come in the form of states enacting laws designed to discriminate and disfranchise African Americans. And what happens? Immediately, the day after Shelby County, North Carolina, a covered jurisdiction, passes a voter ID law. And what follows is many other states and many other voter restrictions. Georgia, Texas, many other states. It's become a partisan football in which this is the way you win political office, by disfranchising the opponents. And in these southern states, the opponents are black voters who tend to vote Democrat. So it's had that important effect, and we'll see where we go from here. But that's the cost of the Voting Rights Act nullification. And then the second question with respect to race, I think that race in the U.S. is just, there are efforts to kind of dismiss race or dismiss racism as a phenomenon in the United States, for sure. Those efforts are seen in this attack on critical race theory, which is a theory of law, theory of justice that recognizes the embedded racial inequality that exists within all of our structures and many of our structures and systems of governance. So there's a way to kind of make race disappear. But in the United States, it's such a prominent feature of our polity and our discussions and our ongoing inequality that there isn't that thought of taking race and there isn't at least that mainstream thought of rejecting race entirely from discussions of law. And so there hasn't been that effort to, in a sense, take race out of the 15th Amendment.
I just want to remind viewers at home that operators are standing by for your questions. Who had... yes, right here.
Bertrall, really fabulous. A really fabulous talk. I wanted to ask you about how these district maps, gerrymandering, and why, for example, every time a state tries to redraw these maps, they were not in violation of the Voting Rights Act, because we have so many states. So, I mean, there's the ability to vote, and then there's what that representation might actually mean in terms of how minority voters get diluted in these maps.
Yeah.
And so I'm wondering what the strategy might be to think about, because for me it's not just about voting anymore. Unless those maps get changed, just the votes are not going to do it, right? So what might the strategy be in terms of reimagining what the Voting Rights Act might be so that things like redistricting actually fall under, could be addressed?
Yeah. You know, the interesting thing about gerrymandering and redistricting, that was the glue that held bipartisan support for the Voting Rights Act together. And it did so in this way. One thing that's sometimes forgotten is that the 2006 reauthorization of the Voting Rights Act received almost unanimous support in Congress, right? Which is unimaginable. And the reason why it did is because there was this Faustian agreement, I guess is what you might describe it as, in which both parties felt like they had something to gain because of the way that the Voting Rights Act enforced against redistricting, right? So what the Voting Rights Act does is it prohibits a state from drawing fewer majority-minority districts than existed before, right? And majority-minority districts, which are districts in which a majority of the population would be minority, often African Americans, sometimes Latinos, sometimes Asian Americans, in which that majority-minority district was understood generally as providing minorities with the opportunity to elect their candidate of choice. And so the Voting Rights Act was actually actively enforced to protect and to ensure that states drew a sufficient number of majority-minority districts, at least to cover states. And it evolved to the point where states were required to draw a proportionate number of majority-minority districts, right? So that was kind of the good thing that the Voting Rights Act did. That was what sort of the Democrats got behind. It led to a dramatic increase in black office holding and Latino office holding and Asian American office holding because of these districts being in place. But the cost is that when you're drawing these majority-minority districts, you're taking minorities out of the surrounding districts, and you're making the surrounding districts more white. And you make those surrounding districts more Republican. And the idea from some experts is that this Voting Rights Act and the way it's being enforced is actually having a detrimental effect on the substantive representation of African Americans, because they are able to elect elect officials within these majority districts, but they have less power because more of these districts in the surrounding area are overwhelmingly majority white. And so the pushback by some groups was like, let's abandon this majority-minority district idea and provide for the drawing of so-called influence districts, in which these districts wouldn't necessarily be 50, 60% minority, but they would be 30, 40% minority, in which the minority would have a pivotal role, perhaps, in that election. But the 2006 reauthorization of the Voting Rights Act was one in which Republicans said, oh, heck no. We love majority-minority districts, right? And the Democrats couldn't abandon it either because it seemed like they were abandoning black and Latino office holding. And so that was ultimately the bargain that was agreed upon. But what happens later is that vote denial emerges as the key tool and key means by which Republicans are seeking to obtain political power, right? And so their thought is like, we'll maintain these majority-minority districts, but we want to have free reign to limit the opportunities to suppress the vote. And the Voting Rights Act is standing in our way. And so then they start to rally behind opposition to the Voting Rights Act, and the majority of the court ultimately acquiesces and strikes down the Voting Rights Act. So that's kind of how it's operated in the future in terms of how it should operate, in my opinion. I think I kind of go along with those who think that influence districts are much more important. I think that our politics has changed such that African American and Latino politicians are having less trouble being elected in non-majority minority districts, and that they can and have been elected in districts that are 30 to 40% minority. And I think that will create greater opportunities for substantive representation in the political process for racial minorities.
Can I take it off for the...
Yes, you may. Yes, you may. Special dispensation. Yeah.
Really fascinating, and I just sort of come at this from a different angle.
Yeah.
And you alluded to it just now in the fundamental shifts in the demography of the country, which are really quite astonishing if you think what's happened in the last 10 years or so. And then within that shift that's going on, the party preferences inside the different groups. Where do you see that going, and how do you see that driving this whole?
Yeah, it's truly fascinating. Now, it's in what's happening. What seems to be happening right now is an interesting phenomenon that you would not expect to be associated with Donald Trump, but Trump has, and the Trump Republican Party is attracting more minority voters. Not a great increase in the number of minority voters, and they're mostly often minority male voters, right? And so there's this kind of machoism, attached to Trumpist republicanism that is drawing in, male voters of all racial backgrounds, right? So I think that if you look at the Virginia election, gubernatorial election, which is going to occur in November, campaigning of the Republican is directed towards Latinos and Latino men. Right, because they see those as an open opportunity to bring them in. Because the Republican Party recognizes that the demographics of their party are not sustainable for maintaining political power. Right, it has been a white male, and often an older white male political party that is becoming a less proportion of the country. And so you need to expand your base somehow, and that's who they are targeting. It's still become a very male party, but they're attracting minority men. Where do I see that continuing to go? I do, because I worry that Democrats are a somewhat dysfunctional party right now, right? And their ability to not only sort of secure passage of policy, which they have the greatest opportunity to do right now than at any time, especially if they're willing to get rid of the filibuster, but their ability to message to different constituencies. They've been an utter failure. They make assumptions about minority constituencies that don't necessarily hold about their wants and their preferences and their needs. And I think that their failure to connect with these constituencies could be detrimental in the long run and may give much more longevity to Trumpist republicanism than I thought would be possible 4 years ago.
Let's not end on that cheerful note. Any more questions? You had one, yes.
Thank you. Fascinating talk. I want to get back to this point of connecting the 15th Amendment to Shelby versus Holder. Yeah. If I understood you correctly, the Supreme Court in Shelby discounted the aspect of what in Germany we call the passive right to vote, the right to hold office, and therefore arrived at the conclusion that everything is fine because so many more minorities were registering and voting.
Yes.
And you trace that back a little bit to a wrong interpretation of the 15th Amendment, which only explicitly says the right to vote, but which, according to your interpretation, also encompasses office holding and all these things. I think what you said in response to a later question, this thing about throwing your umbrella away in a rainstorm, I think it was Ruth Bader Ginsburg who said that in her dissent.
Absolutely.
I think that's closer to the truth because my interpretation would be more cynical. It's not that the Supreme Court misunderstood the 15th Amendment or the meaning of the 15th Amendment. It's that the conservative Supreme Court basically didn't care about the rainstorm and saw a chance to change the politics of it. And I was wondering if I could get your reaction to the cynical interpretation.
No. I mean, there's that kind of drama term or where you're trying to kind of put yourself into this place of unreality to try to enjoy the moment, right? In the sense that, and I think that's part of my work as a constitutional scholar, given the political and partisan dynamics of the court and what they might be for the next couple decades at least, is to, in a sense, put myself in this place of unreality of imagining a court that took seriously law, right? It took seriously the Constitution. And because otherwise it becomes all politics all the way down. And I don't know if there's really much I can say as a contributing actor other than opining, as I sometimes do, to random radio stations about things that I don't have a specific expertise about, but I can talk politics all day, right? And so what my hope is that, first, that the court will be constrained by its sense of need to preserve its legitimacy to operate according to law. But I know that that's kind of living in unreality as well. So my second hope is, well, when the court goes my way, they'll have a tool and understanding that can help them advance a more progressive vision of the Constitution. So I'm just like the conservatives did in the 1970s and the 60s, and anticipating, that conservative court when they were out in the wilderness, right? That we're going to produce this kind of methodology of interpretation that we hope our future court will apply. We're going to develop an understanding of rights that I hope our future court will apply, and they've been successful, right? That's why you get gun rights, Second Amendment that's broadly interpreted. That's why you get originalist methodologies. That's why you get many of the things that the courts produce, because these conservatives laid the groundwork for this court in earlier times. And to some extent, I see myself in that role for that future progressive court.
And just to follow that up a bit, you were talking earlier about the sort of originalism that you engage in methodologically.
Right.
I mean, there is a sense right now that everyone who is continuing to believe in the legitimacy of the court and that it's got to ultimately hew to some principles have to play on that field.
They do.
Otherwise,
They do.
Even though there were other times when the living constitution idea may have been a lot stronger and you could play on that on that field.
Yeah, and I think that the issue is, and for a while, liberals kind of rejected originalism. And what they did was they ceded the whole originalist methodology and territory to conservatives. But originalism does not naturally lead to conservative conclusions, right? It only leads to the conservative conclusion if they are the only ones in the playground, right? And so what scholars have done, Jack Balkin, others, and I'm trying to contribute to that, is to show, okay, let's see where this leads us. And we see that, well, if you look at the principle basis, there are actually quite liberal principles embedded in the Constitution. That radical Republican moment after Reconstruction was perhaps one of the most unique moments in American history in terms of liberal control, or as liberal at the time, control of the bodies of government that could pass amendments. And so that leads to the 13th, 14th, and 15th Amendment. And I believe, based on my research, that there are a lot of liberal principles embedded in these amendments. And we just have to uncover them. Interesting point about conservative originalists is that their entire focal point, almost entire focal point, is on the original Constitution. They're not focusing on the Reconstruction era. They're focusing on 1789. Why do they focus on 1789? Because in my view of it, it's a very aristocratic moment, right? And Republicans are down with inequality, right? They're fine with hierarchy. They're fine with that setup. And the 1789 Constitution provides them with the fuel to advance these conceptions of republicanism. But I think the Reconstruction era provides an opportunity to advance a different understanding of republicanism that I think actually superseded many parts of the original Constitution.
Of course, there's also the argument that, you can have as many originalist interpretations as you
can.
like.
I know, absolutely. Yeah, exactly. But it goes back to the point. If all the originalist interpretations are conservative and you don't see that there are other perspectives, right, you can't actually, it almost legitimizes originalism in an unfortunate way in this conservative form of originalism. And I think it's important to kind of introduce other perspectives and recognize that the court is going to pick and choose which perspective it wants, which will often lean towards its partisan preferences, but you at least brought into public view that there are alternative ways of understanding these constitutional provisions.
Okay, are there any final questions? If not, we will thank Bertrall for a really fascinating evening.
Thank you.
Really fascinating. Before you get up, let me just say that tomorrow, on October 26th, we will hear from our Dirk Eppen Fellow, Amy Kurzweil, who is even in the room tonight. And she will present her artwork, her graphic work, and talk about the art of graphic resurrection. The event will start at 6:30 Central European Time. And then on Wednesday, October 27th, also at 6:30, we'll host an evening with the renowned American pioneer of post-minimalism and the process art movement, Gary Kuhn, and he's going to talk about his work in the context of the fast-changing art world of the 1960s and the 1970s. If you'd like to sign up for these, go to our website, www.americanacademy.de. I feel like I should ask for a political contribution
Right,
then.
exactly.
But I hope you'll join us, and thank you all for coming tonight. And again, thank you to Bertrall.
Yeah, thank you guys.